Hello everyone, welcome to the second part of this lesson where we were talking about the Mediation Bill of 2021. So, in this lesson we would be discussing about topics like the Mediation Council of India, community mediation, pre-litigation mediation, and what were the suggestions that were put forth by the standing committee. Further, we will be dealing as to what is the way ahead, what would be the road ahead after the passing of the mediation bill and its formal enactment. So let's begin with the Mediation Council of India. So, firstly, the Mediation Council is a body corporate with perpetual succession and a common seal to exercise the powers and functions as specified in the bill. So it is a body corporate, it has perpetual succession, that is continuing over a long period of time, perpetually it will continue, and then it has a common seal which is there to exercise the power and functions as specified in the bill. Now, section 33 of the mediation bill tells about the duties of this council. These duties include it can appoint expert committees to discharge its functions. So, the mediation council can appoint expert committees to discharge its functions. Secondly, the Chief Executive Officer of the Council will be responsible for the daily administration and implementation of decisions of the Council. So, the Chief Executive Officer of this Council would be responsible for the daily administration and implementations of the decision taken by the Council. Next up is it is the duty of the Council to promote domestic and international mediation in India by various means. So, the duty which has been enumerated here is the promotion of domestic and international arbitration in India. Next is make India a robust center for mediation. So I guess this pointer needs no explanation. So the the goal towards which the Mediation Council will strive is to make India a robust center for mediation. Next is make guidelines for the continuous education and assessment of mediators. So the Mediation Council will be responsible for framing the guidelines for the continuous education and assessment of mediators. Next is to provide procedures for the registration of mediators, their withdrawal, and their suspension in different conditions. So the Mediation Council would be responsible to provide for the procedures which would be required for the registration of the mediators, their withdrawal, and their suspension. Then is make a professional and ethical code of conduct for the mediators. As we have discussed, there have been no formal regulation for the mediators. So the mediation bill, with the help of the Mediation Council of India, entrusts this duty on the council to make professional and ethical code of conduct for the mediators. Next is hold trainings and workshops in different areas to educate people about mediation. So the task of holding training programs and workshops is also counted on the Mediation Council. This would help them to educate people more about mediation. Next is it has to enter into a memorandum of settlement with domestic and international bodies. So one of the key features of the Mediation Council is also to enter into MOUs with domestic and international bodies. Then the next is recognize mediation institutes and service providers. So the Mediation Council is entrusted with the duty to recognize the mediation service providers and institutes. Also, it is responsible for the publication of necessary information and data. Next, it has to maintain an electronic record of mediated and settled agreements. So it is the task of the Mediation Council to keep this data in electronic form as to which of the agreements, which of the disputes have been mediated and a successful settlement agreement has been arrived into. Now next we'll be dealing with the concept of community mediation. So community mediation, as the name sounds, what is community mediation? So where the dispute involves or affects the community at large. So when we talk about community mediation, the section 44 of the mediation bill talks about community mediation, and it says that if there is any matter which affects the peace and harmony of the community or locality, it can be settled through this kind of mediation with the consent of the concerned party. So if there is any matter which affects the community at large, the peace and the harmony of the community at large, then those matters can be taken care of by community mediation. For this, the consent of the concerned parties has to be taken. Now, to initiate a proceeding in the process of community mediation, an application has to be written by the parties to under the Legal Services Authorities Act of 1987. So the application has to be under this statute or to the district magistrate or the subdivisional magistrate, and then the mediators would be appointed through the panel. So how does the community mediation work? The process we have just discussed, that the application has to be written by the parties as per the Legal Services Authorities Act of 1987, and or to the district magistrate or to the subdivisional magistrate, who will then appoint the mediators through a panel. Now the procedure for such mediation, that is the procedure that we just discussed, has been given under section 45 of the bill. Now the bill also provides for the matters which are not fit for mediation. These matters are provided in the first schedule of the bill. So these matters include dispute that is not submitted for mediation. So a dispute which has not been submitted for mediation is not fit for mediation. That's kind of obvious here. Next is dispute that involves allegations of fraud, forgery, impersonation, coercion, etc. So this point we have discussed in the part 1 of the video, that these disputes where the allegations pertain to fraud, forgery, impersonation or coercion, they will not come under the ambit of mediation. Next is disputes relating to minors or deities. So again, these disputes will also not be covered by the mediation bill. And next is disputes over the prosecution of criminal offences. So for that also mediation cannot be taken. Next is matters prohibited by public policy. So the matters which have been prohibited by public policy, those matters can also not be mediated. Next is disputes where the rights of the third parties are infringed and they are not parties to the mediation. So where there is a dispute where the right of a third party is infringed and that party is not a party to the dispute, is not a party to the mediation settlement dispute, then that matter will also not be dealt by mediation. Now, as we have earlier spoken about this thing, that the mediation bill that has been submitted for the suggestions to the standing committee. So, as per the reports of the standing committee, there have been many suggestions which the committee has given. These suggestions include, first is regarding the mandatory pre-litigation. So, when we talk about mandatory pre-litigation, So in this we can say that the standing committee has to say that a party to a dispute cannot be forced to take mediation as a prior step to the litigation process. So this would be somewhat of coercive nature, and this would further result in the delay and the pendency of cases. Next is non-commercial disputes. So as we have already discussed in part 1 about the applicability and non-applicability of the bill, so in that we read that in that we read that only to commercial the bill is applicable only to commercial disputes if any of the parties are the central or the state government, public bodies, local bodies, etc. So there we referred that in case the exception was of government parties being involved in a commercial dispute. So when we talk about the government bodies being involved in the commercial dispute, so why are the non-commercial disputes involving government parties not dealt under the act, under the bill? I'm so sorry, it's a bill till now. So why are the non-commercial disputes which involve governmental bodies not dealt under the mediation bill? Next is regarding the qualification of members of the council. So the bill provides for the appointment of the members of the council, but there is no clarity as to what would be the qualifications for being a member of the council. What would be the qualification? What would be that experience criteria? That has not been stated. Next is international mediation. So another issue in this bill is another issue in this bill is that an international mediation will only be considered if it was conducted in India. So international mediation may only that mediation will be covered which is conducted in India. But there is no provision in the bill for the settlement and agreements of international mediation conducted outside. So if the mediation is conducted in India, then the bill relates to it. But what if the mediation is conducted outside India? So the bill is silent upon that. Whether such agreements will be enforced or challenged is not addressed in the bill. Now there were some suggestions that were put forth by the standing committee. These suggestions included that the pre-litigation mediation must be made optional and voluntary. Next is the appointment of the members of the council should be done by a separate committee. There should be a separate selection committee. This would ensure fairness and transparency. Next is that the bill talks about a central mediation council. What about the state mediation councils? So the standing committee suggested that there should be state mediation councils as well, which would be under the supervision of the central council. Next is mediation should be registered under one authority, which can be the Mediation Council of India, and be given a unique registration number. So when we talk about the mediators, the bill says that the mediators can be registered under one body. That body would be the Mediation Council of India that we just discussed, and these mediators would be given a unique registration number so that the training of these mediators can also be facilitated easily. Next is reducing the time period of mediation. As we discussed that the time period in which the mediation proceeding should be winded up would be 180 days as per the bill as of now. But the committee has suggested that this period should be reduced to 90 days and an extension of 60 days should be given for speedy disposal. Next is that the draft bill provides for domestic mediated settlements that a domestic mediated settlement may be challenged on the ground of gross impropriety, but it does not define the scope of that term. So, a mediated settlement can be challenged on the grounds of gross impropriety. This ground has been mentioned in the bill, but what amounts to this gross impropriety is not stated. What would be the scope of this word is not stated. So that should be clearly determined. Next is the consequences of non-registration of a mediation settlement agreement have not been mentioned. So what if the mediation settlement is not registered? What would be the consequence of that? That has not been mentioned in the draft bill. That is the mediation bill of 2021. So that should be included. Now, these were the suggestions which were put forth by the standing committee. Now, what is the way forward? See, when we read the entire mediation bill, we derive that all in all, it is a very great initiative on the part of the government to take a step forward towards the positive development. And if this bill is passed, it will definitely reduce a lot of burden from the courts, and it would reduce the pendency of cases. Also, if this bill becomes an act, that is the Mediation Act, so it would it would clear a lot of ambiguities, and it would have elaborate provisions which would facilitate the alternate dispute redressal mechanism of mediation. Ambiguities regarding the appointment of mediators, the conduct of mediators, everything would be cleared with the coming up of this bill. Then clarification to be there to which entities should be recognized as service providers and what should be the qualification of the mediator. So clarities with respect to what should be which institutes or which people should be recognized as service providers, and what would be the qualification of a mediator, and that is also one point to be taken into consideration. Now, we can just say that after a reading of the mediation bill, we strongly feel that even considering the suggestions taken from the standing committee, so what would be the final act? How will the final act look like after these suggestions? That is a very much awaited step. That's all. I hope you enjoyed this lesson. Thank you so much and have a great day. Thank you.